Professor Anderson is a professor of law at American University. His academic articles have been cited by the Supreme Court, the U.S. Court of Appeals for the Federal Circuit, and the New York Times. Professor Anderson clerked on the Court of Appeals at the Federal Circuit. He practiced patent litigation at Latham and Watkins. I spent a lot of time not as an appellant, but as a friend of many of the members of the Federal Circuit Court of Appeals, as the professor probably knows. And he received a JD from Harvard Law School, bachelor's degree in physics from the University of Utah. And Professor, please go ahead, sir.
Good afternoon, Senators. Thank you, Chairman Leahy, Ranking Member Tillis, and the other members of the subcommittee for the invitation to testify. It's an honor to testify on the predictability and fairness of proceedings at the Patent Trial and Appeal Board. I'm a professor at American University, Washington College of Law, and my areas of expertise are in patent law, federal courts, and intellectual property. A specific focus of my scholarship has been directed towards federal courts, federal district courts, who seek to attract patent cases to their courtrooms. This court competition for patent cases, I believe, is a threat to the judiciary's legitimacy, not just in patent law, but across other areas of federal law as well. It is with this concern in mind that I will focus my testimony today. I will begin my testimony by briefly describing how the PTAB's FinTIV ruling has been used by federal district court judges who seek out patent cases, and how that active solicitation of patent cases threatens to erode public confidence in the judiciary. In 2021, roughly 25% of all patent cases were heard by a single federal district court judge. As Chairman Leahy and Senator Tillis referenced in their November 2021 letter to Chief Justice Roberts, this extreme concentration of patent cases is troubling for the judiciary. I agree with Chairman Leahy and Senator Tillis' views on the current problematic state of patent litigation. This extreme concentration of patent cases and judges actively encouraging plaintiffs to file in their courtrooms undermines the public perception of fairness in judicial proceedings. But this hearing is about the PTAB. I believe the PTAB has been a great benefit for the U.S. patent system by providing a cost-effective means of challenging the validity of patents. This leads to a strengthening of the competitive landscape and is a positive for the American public. But I also believe the FinTIV decision at the PTAB has led to increased uncertainty. As Senator Tillis said in his November 2021 letter to the director of the PTO, it has led to harmful incentives for forum shopping and inappropriate judicial behavior. Furthermore, just this morning, the PTO issued guidance on the application of FinTIV that limit FinTIV's applicability. Today's PTO guidelines are welcome on the whole, but I would suggest that the PTO ought to rescind the FinTIV rule entirely. The PTAB's FinTIV rule is based on the laudable notion that the PTAB ought not institute review of a patent if a district court or the ITC is going to issue a ruling on the patent's validity at an earlier time. But the current 6-factor test provides virtually no certainty of outcome, and worse, is influenced by plaintiffs who can strategically, file their cases in an effort to avoid PTAB review. Plaintiffs who want the PTAB to avoid PTAB review can choose to file their case in a district court that has a reputation for not issuing stays and setting very early trial dates. These dates are not good indicators of when a district court will issue a decision. A recent study found that 94% of those trial dates relied on by the PTAB in FinTIV turn out to be inaccurate. The FinTIV ruling forces the PTAB to analyze the trial dates of district courts and to grapple with comparing the duplicative effort between the district court and the PTAB. Furthermore, it forces parties to waste attorney hours arguing about the 6 cumulative factors. A much better and easier solution would be to eliminate FinTIV entirely and limit the PTAB's institution decision to those factors that are enumerated by Congress, including the 1-year ban. Eliminating FinTIV would also have the benefit of eliminating the possibility that district courts that set aggressive trial dates in an effort to preclude PTAB review. The PTAB would be freed from the labor-intensive analysis involved in FinTIV, and district courts would not be able to use trial dates in an effort to avoid PTAB review and thereby attract patent plaintiffs. Thank you for your time, and I look forward to your questions.
Well, thank you very much, and I'll begin with Mr. Kane. I think everybody knows there's currently a chip shortage that's affecting all Americans. There's even car manufacturers of popular vehicles have them sitting in their lot just because they are missing a few chips. Chip manufacturers like Global Foundries, with what I believe is an exceptional facility at our home state, components, phones, cars, computers. Patents are an important part of your business. I understand Global Foundries has over 7,000 U.S. patents. When we passed the Leahy-Smith American Invents Act 11 years ago, we wanted to make sure the patent office could take a second look at patents that are of particular relevance to the public, review them, and so on. In your experience, Mr. Kane, has the PTAB been a fair adjudicator of patent validity? Make sure you read.
Thank you, Senator. Certainly. We've very much been happy with the PTAB, both as a patent owner and as a petitioner. As you said, there's an extreme amount of innovation going on at our facilities. Every chip we put out must have hundreds, if not thousands, of pieces of innovation inside of it, and we do count on the system to protect that innovation. And we've seen very fair and very reasoned decisions coming out of the PTAB as to the validity of those patents.
Do you consider the PTAB judges preferable to an ordinary court and jury?
PTAB judges are specially positioned with their technical background and the fact that they live and breathe patent law every day. It is their bread and butter, novelty and non-obviousness. And so they have a better look at such issues than almost anyone in the world.
I had a dear friend of mine, Judge Lynn, who now has senior status, been in the federal circuit, and I remember talking to him about some of these patent cases and realized this is a specialized area. Let me ask Professor Anderson. I've always thought the PTAB could be forum predictable and fair, but a previous patent office director began using the discretion that's in the Patent Act to deny review of patents based on the status of ongoing litigation in district courts without regard to the merits. The kind of discretionary denial injected uncertainty, I believe, into the patent system. I understand that just today, Director Vital, and we've mentioned this, released new guidance cutting back on the impact of that policy. I believe the statute should be as predictable as possible. So, Professor, my understanding is projected trial dates are inaccurate 94% of the time. A discretionary denial policy built around this one, I feel, would cause uncertainty and unpredictability in the patent system. Do you agree?
Yes, Chairman, I definitely agree. And even worse than that, I think there's some gamesmanship involved in where you file your case and in order to avoid the PTAB. So I mentioned there's one district court that has 25% of patent cases, and one of the appeal to plaintiffs, I gather, is that filing in that courtroom makes it less likely that PTAB will review your patent under the FinTIV case. And that's why I think this act goes a long ways, and the PTO's actions this morning go a long ways towards limiting that discretion.
Well, in fact, going on that, Senator Tillis and I wrote to the Judicial Conference about the ability of patent owner plaintiffs not only to pick the venue, but to pick the precise judges. I think what you're referring to is a district court judge who's promised patent owner plaintiffs a trial date will be soon enough they can deny them discretionary denial of the PTAB. 25% of the district court patent litigation in this whole country is being handled by that single judge. Does that skew the patent litigation in this country?
Yes, I think having 25% of the patent cases or any type of case before one judge is not the system that the Constitution or Congress designed. And so I think having that many cases, that much power in one judge's hands is not something we want to encourage, for sure.
Thank you. I'm going to go and vote